Today, I'm really excited to have two guest experts on harassment and employment discrimination law, Professor Rachel Arnow-Richman and Professor Nicole Porter. And we're going to play a game called Harassment or Not, where we're going to hear about a real harassment case, and then we're going to guess whether the court thought it was harassment or not.
The plaintiff was a comedy writer's assistant who worked on the production of a popular television show called Friends. The show revolved around a group of young, sexually active adults, featured adult-oriented sexual humor, and typically relied on sexual and anatomical language. Before plaintiff was hired, she had been forewarned that the show dealt with sexual matters and that she would be listening to their sexual jokes and discussions about sex and transcribing the jokes and dialogue. After 4 months of employment, plaintiff was fired. She then filed this action against 3 of the male comedy writers and others, asserting, among other things, that the writers' use of sexually coarse and vulgar language and conduct, including the recounting of their own sexual experiences, constituted workplace harassment.
What do you think? Do you think that's harassment or not?
Wait. Full disclosure. What if we know the case and then taught it last week?
I know the case too. We can just comment on it. I mean, we know the case.
Yeah, I figured.
So I had not heard all of the, I know of this case. But the piece that added in that makes me feel differently about it than I think maybe I felt about it before was the writers talking about their own sex lives, using vulgar language to talk about their own sex lives, because I don't think you need to do that to be writing and doing the dialogue for the show, right?
Yeah.
So if that was happening a lot and we didn't really get that much information about it, I think I'd be more likely to say that should be considered harassment.
And as it happens, I just taught that case last week.
You did?
Yeah, not in employment law. I actually never taught the case in employment law. I taught it in entertainment law.
Wow, okay.
Oh, yeah. And so I think a big piece of the court's reluctance to get involved there is because of the fact that it's a creative process, and the law on discrimination in the context of creative undertakings is pretty deferential to the artist, which is a studio. I mean, it is a big business. It's not a struggling artist.
Mm-hmm.
To the point, if you look at the case law on casting, for instance, there's a pretty strong free speech defense to production companies casting along what would seem to be racial lines or gender lines in a straight kind of discrimination type of disparate treatment way. The part that I struggle with in terms of thinking about workplace rights is that the case, I think, really shows the structural barriers that exist for women in Hollywood. And so technically there's no harassment there, in the sense that it's not directed just at women. It's not based on someone being a woman, but it's an incredibly male sort of set of behaviors. And I think of, Tristan Green's research, Anne McGinley's research, just on the performance aspects of masculinities and how that really creates environments where women are not able to access the work, and they are going to be excluded or feel marginalized in the course of doing that work. So it's a really, really problematic case. There were women writers who were engaged in the sex-based behavior.
That's right. Yeah, I forgot about that. Yeah.
But what I've always wanted to know is how many women were in the room.
So she was an assistant. Does that mean that she was transcribing? So she was not in the room the whole time, or she was?
It was not her job to be in the room. And I don't know whether it complicates it on the one hand, in the sense that, she's not directly exposed to it necessarily, but it still pervades her work environment.
Sure.
And she's not a writer. Like, if the case were brought by one of the writers, that would be, in some ways, you know, both an easier and a harder case. You know, if we believe this idea that it's part of your job.
Right. So it's like the BFOQ for harassment is the way I think about it, right? Like if you work in a sexualized industry, you know, I mean, even let's say probably even Hooters, but certainly a strip club, you don't get to claim that it's not going to be actionable if you claim that people are commenting on your body when you're stripping, right? Like that's just what, I don't know if they officially call that a harassment BFOQ, but that's just how I've always referred to it.
Big tech companies used to have people who were in the jobs of, you know, reviewing objectionable content that's been flagged and assessing, you know, some of this exploitative content. And it was their job to watch this content that was extremely offensive on any number of continuums. And I think this case actually, I think, has been part of the case law on, you know, the idea that there are some jobs that are inherently offensive to perform.
The comments that are personalized.
Yeah.
You know, on the one hand, the personalized comments, right, that is the creative process. You write from your lived experience, and it has to be shared because the writing is collaborative. It's extremely collaborative. But there are some things, and I think, Nicole, you mentioned, like they made comments about the actresses that were pretty offensive and hostile at times.
Yeah.
And so there may be a line that can be drawn there. Obviously, the court wasn't going to do that.
About, like, you know, just sort of treats the writer's room as a given, and the culture of the writer's room, which tends to be very misogynistic, and they treat that as a given as something that cannot be changed, an essential feature of the job, which may or may not be true if writers' rooms were more diverse.
I completely agree with that.
When I joined in-house, they had like filters set up to catch any emails that had offensive words. And so I asked sort of the male attorney that had been doing this before I got to the company and was going to take over all the labor and employment work. I said, well, how did you decide? And the male lawyer had sat down with the male director of HR and came up with all the words that they thought that the email, you know, whatever filters you use, right, should be catching. And I said, well, that's interesting. Didn't anyone think that maybe they should have had a woman's perspective in coming up with that list? And it seemed like that was like the craziest thing that anyone had ever heard. And I'm like, no, that's not crazy. Like I sometimes use that as sort of like, does diversity matter in employment like it does in higher education? Like when we're talking about affirmative action, I know I'm getting a little off topic, but you know, like that seems relevant to me, right? Like that the people that make up the committees or the decision-making bodies are going to have different experiences.
Yeah.
And so like how many women were in this writer's room, I think is what Rachel was mentioning is really relevant.
That's a great point.